Welcome, everyone. Today we are wading into a pretty significant and very recent Supreme Court opinion. It's Environmental Protection Agency versus Calumet Shreveport Refining. Now, on the surface that sounds maybe a bit dry, like deeply technical, lots of dense regulations, venue rules, obscure bits of the Clean Air Act. But our mission today really is to cut through all that legal complexity. We want to explain this critical regulatory fight. And it boils down really to a simple question for you. When a big agency like the EPA makes a decision, one that hits local businesses hard, where exactly should those businesses go to sue?
It's a huge question, honestly.
Yeah.
And the Supreme Court's answer, as we just saw, it all hangs on figuring out what Congress meant when they set up the Clean Air Act's judicial review rules. You can almost think of it like a traffic control system for lawsuits. Congress wanted the really big, nationally important regulatory challenges, the ones affecting policy everywhere, to go straight to one place, the D.C. Circuit Court of Appeals. It's a specialized court.
Okay, so national stuff to D.C.
Right. But if the issue is just local, or maybe regional, it's supposed to stay closer to home, in the regional circuit court where the impact is felt. This case was really the showdown over where you draw that line. Does the EPA's big national policy thinking override the very local individual impact of its decision?
And the specific conflict driving this, it involves the EPA, small oil refineries, and this major federal program, the Renewable Fuel Program, right?
The RFP.
Exactly, the RFP, a federal mandate. Basically, it requires most refineries in the U.S. to blend certain amounts of renewable fuels, like ethanol, into the gasoline and diesel they produce. Now, the small refineries we're talking about here, they're defined as processing no more than 75,000 barrels of crude oil a day. So they're the smaller players in the industry.
The little guys.
Pretty much.
Sure.
And they have this specific ability under the law to petition the EPA for an exemption from the program if they can show it causes them disproportionate economic hardship. Okay, and the cost of actually complying seems to be the main issue here, the hardship trigger. You said they need to blend the fuel. How does that work, and why is it so tough on the small guys?
Well, this is where we get into something called Renewable Identification Numbers, or ANs, RINs.
Yes, RINs.
Think of a RIN as like a compliance ticket. A refinery gets these tickets either by actually doing the blending of the renewable fuel themselves, or, and this is key, they could buy these RINs on an open market. It's a tradable credit system. And often they have to buy them because maybe they aren't set up for blending that specific fuel type.
And buying them can get expensive, I imagine.
Extremely expensive. The market for RINs can be really volatile. For big oil companies, they can often absorb those costs or manage them more easily. But for a small refinery, those fluctuating RIN costs can be a massive financial hit.
So that financial pain, that's their argument for disproportionate hardship.
That's the core of it, yes.
Okay, so back to the legal structure. Congress set up this filtering system for lawsuits under the Clean Air Act. You mentioned it directs lawsuits based on their scope. How does that breakdown work exactly?
Yeah, it's essentially three categories. It's all laid out in the law, section 7607B1 of the Clean Air Act, if you really want the detail. Category 1 is pretty straightforward. Any EPA action that is nationally applicable, meaning it applies the same way everywhere across the country, that goes straight to the D.C. Circuit, no question.
Makes sense, like a big new national emissions standard or something.
Exactly. If it affects everyone equally, you challenge it in D.C.
Got it. What's Category 2?
Category 2 is basically the default for everything else. Actions that are locally or regionally applicable. So if the EPA does something that only affects, say, one specific plant in Louisiana, or maybe a few states in one region, like the Fifth Circuit,
then the lawsuit stays in that region's court.
Correct. The challenge is supposed to stay local, in that regional circuit court.
Okay. And then there's Category 3, the exception, you called it. The one causing all the trouble here.
Precisely. This is the tricky one. Category 3 covers actions that are locally or regionally applicable, like denying one refinery's petition, but they are also based on a determination of nationwide scope or effect.
So the action itself is local, but the reasoning behind it is national.
That's the idea. And crucially, if the EPA actually publishes a finding saying, yes, our reasoning here is national, then those challenges also get funneled to the D.C. Circuit.
So the whole case turned on whether the EPA's denial of all those refinery petitions fell into that third complex category.
Exactly right.
And this whole situation got triggered after a previous Supreme Court case back in 2021, HollyFrontier. What happened there?
Right. HollyFrontier basically confirmed that small refineries could, in fact, keep applying for these hardship exemptions year after year. That decision meant the EPA suddenly had this huge backlog of pending exemption petitions they had to deal with.
A lot of paperwork landed on their desk.
A huge pile. And the EPA decided, okay, let's handle these efficiently. In April and July of 2022, they denied 105 of these small refinery petitions. But they didn't do it one by one.
How did they do it?
They issued 2 big omnibus notices, basically mass denials covering dozens of refineries at once.
A bulk denial. And EPA immediately said, because we did this all at once, in a big national notice, any challenge has to go to the D.C. Circuit.
That was their argument. But just issuing a big notice isn't enough. To really make the case for D.C. jurisdiction under that third category, they needed to show the denials were based on national reasoning.
Foundational nationwide reasoning.
Absolutely. And they pointed to 2 core determinations, which they argued had nationwide scope and effect, to justify denying all 105 petitions no matter where the refinery was located. These 2 determinations are really the pillars of the EPA's argument and ultimately their win at the Supreme Court.
Okay, what was the first pillar?
The first was their specific interpretation of disproportionate economic hardship. The EPA adopted a pretty narrow view. They argued that the hardship had to be directly caused by the need to comply with the RFP itself, meaning buying those expensive RINs.
So general financial problems wouldn't cut it, like if the price of oil dropped and the refinery was struggling overall.
According to the EPA's interpretation, no. That general market stuff doesn't count. You have to show the hardship stems directly from the program's compliance costs.
Okay, that's pillar 1. Narrow definition of hardship. What's the second pillar? This sounds like the more controversial one.
It is. The second pillar is where the real nationwide scope argument comes in strongly. It's what's called the RIN pass-through theory.
RIN pass-through theory. Okay.
This is a broad economic theory that the EPA relies on heavily. The theory argues that refineries don't actually bear the cost of the RINs they have to buy.
Wait, how can that be? They still have to pay for them, right?
They pay for them, yes, but the theory is that they fully pass that cost through to consumers in the price of gasoline and diesel at the pump.
So the argument is the refinery buys the RIN, raises the price of gas by that amount, and the driver pays it. The refinery is made whole.
That's the theory. If the cost is fully passed through, then the refinery isn't the one suffering the economic burden, the consumer is.
And if the refinery isn't suffering the burden,
then they can't claim disproportionate economic hardship based on RIN costs. This theory creates a very powerful, almost automatic presumption against granting any exemptions, regardless of a specific refinery's local financial situation.
wow, that is a sweeping national theory. It basically says your local spreadsheets don't matter that much because our big economic model says you're passing the cost along anyway.
That's a good way to put it. It's an overarching economic model used to justify regulatory action across the board. Definitely a determination of nationwide scope.
Fascinating. But obviously the small refineries didn't like this outcome or this reasoning, and they didn't want to fight it out in D.C.
No, they didn't. They filed their challenges locally, in their regional circuit courts. Now, most of those courts looked at the EPA's arguments and either transferred the cases to D.C. or just dismissed them, basically agreeing with the EPA on venue.
But not all of them.
Not the Fifth Circuit. The Fifth Circuit Court of Appeals, which covers states like Texas and Louisiana where many of these refineries are, they held on to the cases.
What was their reasoning?
They essentially said, look, the legal effect of denying Calumet Shreveport's petition only impacts Calumet Shreveport right here in our circuit. It doesn't legally change anything for a refinery in California. So they concluded the action was local. They kept the case. They actually ruled in favor of the refineries on the merits, and they threw out the EPA's denials.
And that created the conflict. You had the Fifth Circuit saying, this is local, and other circuits effectively saying, no, it belongs in D.C.
Exactly. A classic circuit split, which is prime territory for the Supreme Court to step in.
Right. So the Supreme Court took the case, granted certiorari, specifically to clear up this confusion about venue. And they laid out a two-step test, right, to figure out where these challenges belong. What was step 1?
Step 1 was all about identifying the relevant action. What is the specific agency action being challenged? The EPA argued, well, the action is our big omnibus notice, the mass denial. That's national.
But the court didn't buy that.
No, they rejected that pretty firmly.
Yeah.
The court said you have to look at the underlying statute that authorizes the action. The Clean Air Act allows a single small refinery to petition for hardship relief.
Okay.
Therefore, the court reasoned, the denial of that single refinery's petition is the legally relevant action for deciding venue. not how the EPA chooses to bundle its decisions.
So the EPA can't just package 100 local decisions together in one document and magically make the action itself national.
That's what the court said. And since denying one specific refinery's petition only applies to that one entity in that one place, the court concluded the action itself is paradigmatically, locally, or regionally applicable.
Okay, so action local, that seems clear, which immediately pushes us to step 2, right?
Right into step 2. Applying the exception. Okay, the action is local, but was it based on a determination of nationwide scope or effect?
And this is where the definition of based on becomes absolutely critical.
Hugely critical. This was maybe the core interpretive move in the whole opinion. The court said based on is a demanding standard. It's not just simple but for causation like, well, the national theory was a reason.
It has to be more than just a reason.
Much more. The court said the nationwide determination must lie at the core of the agency action. It has to be the primary explanation and driver of the EPA's final decision. Peripheral reasons, minor factors, they don't count for triggering this exception.
Primary driver. How do courts figure that out? Isn't that kind of subjective? Like trying to read the agency's mind based on its paperwork. That sounds like it could lead to a lot of fights just about where to have the real fight.
That's a really sharp point, and it's exactly the concern Justice Gorsuch raised in his dissent, which we should touch on. But the majority felt that, in this specific case, the EPA made the primary driver pretty obvious.
How so?
Because the EPA explicitly used those two big national determinations, the narrow hardship definition and the RIN pass-through theory, to justify a presumptive resolution to deny all 105 petitions. Their logic flowed directly from those national points. Premise 1, narrow hardship. Premise 2, RIN pass-through. Therefore, conclusion, deny essentially all petitions.
So the national theories did the heavy lifting.
Exactly. The court said the EPA's review of the refinery-specific local facts, the actual financial data submitted by each refinery, that part was deemed really confirmatory. It didn't really change the outcome dictated by the national theory.
So the local facts were, in the court's view, peripheral.
That's the exact word they used, peripheral, because those national determinations were the primary driver, the core justification, even though the action itself, the denial, was local.
The exception kicked in and the venue shifted to the DC circuit.
That's the final holding. The locally applicable actions were based on determinations of nationwide scope or effect that formed the primary driver. Therefore, the challenges belong exclusively in the DC circuit. The Fifth Circuit got it wrong by keeping the case.
Okay. Before we get to the big takeaways for everyone listening, let's briefly cover that dissent. You mentioned Justice Gorsuch had concerns about this primary driver test.
Yeah, Justice Gorsuch wrote the dissent, joined by Chief Justice Roberts. His core argument was that the majority's test, this whole process of weighing primary versus peripheral reasons, is just too complicated and, frankly, unworkable in practice, too messy, and likely to lead to more litigation about litigation. He pointed out that the specific part of the Clean Air Act dealing with small refinery exemptions only talks about refinery-specific local factors. It doesn't mention needing some grand nationwide determination. So, Gorsuch argued, the EPA made a choice to layer on this national economic theory, but that choice shouldn't warp the venue rules Congress set up for what are fundamentally local decisions based on local facts. He thought regional courts were perfectly capable of handling these.
So he feared this test would just create endless, expensive fights over venue, trying to psychoanalyze agency reasoning.
That's the essence of it. He predicted it would lead to expensive and difficult venue litigation. Pretty much any time an agency uses a mix of national policy and local facts, which happens all the time.
Interesting contrast. The majority wants to funnel big policy disputes to DC for consistency, even if the trigger is local, using this primary driver test. The dissent worries the test itself is too complex and undermines the focus on local facts.
A perfect summary of the tension, yeah. So what does this mean practically for you, the informed citizen, trying to make sense of this? But the big takeaway is that this decision really shores up the DC Circuit's central role in reviewing major regulatory policy. Even if an agency action hits just one company in one place, if the core reason behind that action is a broad national policy, a big economic theory, or a sweeping interpretation of the law,
then the fight goes to Washington, D.C.
Correct. The challenge has to be filed there. The court essentially doubled down on what it sees as Congress's intent, channel these nationally significant regulatory disputes, the ones driven by core policy reasoning, to that one specialized court.
Why is that seen as important?
The idea is to promote consistency. You avoid having different regional courts come up with conflicting interpretations of the same federal law, like the Clean Air Act. It prevents that kind of patchwork quilt of legal rulings across the country on major national programs.
Okay, so this deep dive really shows how a seemingly obscure rule about where you can sue can actually shape the entire landscape for challenging major regulations. We've unpacked locally applicable versus nationally applicable, and this crucial, maybe controversial test of whether a national determination was the primary driver.
Absolutely. And that RIN pass-through theory is a great example of such a powerful national determination. The court found that the EPA's reliance on that theory, that national economic model, was so central that it rendered the individual local facts presented by the refineries merely peripheral.
Which really brings us to a final thought for you to mull over. In today's world, with incredibly complex regulations affecting businesses large and small, how much weight should we give to these big national economic theories or policy goals, things that apply broadly to everyone?
Especially when weighed against the very specific, very local, sometimes painful individual facts of businesses on the ground, just trying to comply, trying to survive under these mandates. Where should that balance lie? That's something we're thinking about.